And this transitions into our next case. One response of the cruise industry is some of the cruise companies are requiring vaccinations even for children, or at least certain age groups, those teenagers, 12 to 15 years old, following the CDC saying they were going to authorize use of this vaccine for that age group because it hadn't been approved out of the gate. And that has led to two different legal actions. Bobby Kennedy has filed a citizen's petition with the FDA challenging that authorization for the children's defense. I think it's children's health defense. I always get that confused.
Yeah, let me look it up. I took a screenshot just as I mistake. I get it wrong as well. Tabarnouche, where is it? You know what? Forget it. I can't find it fast enough. I think it's children's defense.
Yeah, I think that's right. Children's health defense, and people in the chat will probably know. And then the other one is the doctors group that filed a suit on behalf of doctors, on behalf of patients, parents, on behalf of kids in Alabama. They didn't file actually a suit. They filed a request for an injunctive relief, which you can file a petition for that in advance of the suit itself if you want, by an old friend of mine, Larry Becraft, who I always know is Larry used to say, it's beer 30, and he's like, time to get a beer. It's like, oh, it's beer 30. It's beer 30 somewhere in the world. So that was one of Larry's lines. He's from Alabama. And what they're challenging is the same thing that Bobby Kennedy is challenging, just in a different way. And the argument is that the emergency use authorization standards were not met yet to authorize the vaccine for people that are under the age of 16. And it's a long, long complaint. If people want to look at all the different, they use it as an opportunity, or petition for injunctive relief. They use it as an opportunity to present a wide range of arguments. But legally, it boils down to, did the FDA or the CDC meet their requirements under the emergency use authorization statute? And that's part of it. They touch on it a little bit. If you read the emergency use authorization statutes and related statutes that are specific to kids and other aspects, some of these statutes appear to have been written for national security issues. In other words, anticipating weapons attack, chemical weapons, biological weapons. They don't quite appear to have been originally intended to deal with a pandemic necessarily. So that's one set of questions. And from that flows a whole host of regulations that it appears that they have to meet a bunch of tests. They have to say, this is the case, this is the case. The big thing they're supposed to do is create a risk-benefit analysis, and two levels of risk-benefit analysis. They're supposed to do an administrative process whereby they determine that the risk-benefit analysis warrants the emergency use authorization for this particular population group, people under the age of 16. And secondly, they're supposed to help produce that for the public so they meet the informed consent component, because the Nuremberg Code has been codified in these laws. And courts have recognized this, that the old Nuremberg Code 1947, after the Nuremberg trials, established the legal precedent that said international law was enforceable in this space, that we would never do experimentation. And this is, again, because this drug is an experimental drug, because it's an emergency use authorization drug. So a lot of people had questions about clinical trials and whatnot. The general rule that the FDA follows is they require usually about a 1 to 2 year time period before they approve new drugs, including vaccines, especially for children. And that time frame hasn't been met. So there have been clinical trials, just not of the length and the duration, so they can observe the consequences long enough in order to be able to authorize it under traditional authorization. That's why all of this is under emergency use authorization. And they're challenging not so much the idea of emergency use authorization. They're challenging or the informed consent component, because that's not the issue here. They're challenging whether or not they followed that as applied to this population group of people between the ages of 12 and 15.
And the suit is it's in the District of Alabama, America's Frontline Doctors, etc., versus the government. It is a law. It's 80 pages. It goes into a great amount of detail. There's quite a bit of hyperbolic rhetoric in it, which I think is.
Well, it's Larry Becraft. So Larry never holds back. That's not Larry's nature.
And so, I mean, I say it's good and it's bad. It's good in the sense that it'll get the people who support it, encouraged or invigorated. It's going to get the people who think that those people are wrong, thinking they're wrong, and they're just using certain language in general. But no, it is an amazing thing that it highlights what emergency use authorization is about, the calculations that should go into it when it comes to risk versus reward. And the lawsuit itself, a lot of the allegations focus on the fact that other than being experimental even by the National Institute of Health Standards or determinations, when the risk level for children, statistically, we know what it is. So when the risk level for children is what we know it is after a year and some of this pandemic, can it even meet the required elements in order to be qualified as emergency use for kids? And we're getting to the level where it was at one point, are they going to force vaccination of adults? Are they going to make two-tiered system? I brought up a couple of chats, like you can't do X, Y, and Z if you're an adult, but now if it's going to be the same thing for kids, and it might not be forced, it's just going to be economically, socially compelled. And the lawsuit is seeking an injunction to immediately halt that. But Robert, where in the States are they looking to make this policy or make this, if not law, some form of requirement for children? People know what's going on in Canada, but I didn't know that we were at this stage in the States.
The District of Columbia. So Bobby Kennedy's looking at bringing suit there. But what I thought was really intelligent, both about Bobby Kennedy's challenge and this challenge by the doctors group brought by Larry Beecraft, is there in this context, like in all the lockdown context, one of the constant complaints and concerns was brought up by Judge Stickman in the decision that came out of the Western District of Pennsylvania, that for those asking, yes, it's still sitting at the Third Circuit. As predicted, they were just going to sit on it, which by the way, for all those people that are highly critical of his decision, if it was so bad, they would have reversed it in full and in published opinion. They haven't. That's because they know it's not easy to do so. They're hoping it gets to the point where it's moot and they never have to deal with it. But the typical Third Circus. But that's another story for another day. But in that is that they're showing that at least in the vaccine context, a lot of the principles that should have been in the lockdown context and other public health intervention context, including mask mandates, is actually put in the law and the regulations, which is this cost risk benefit analysis that, as we know from the Judge Stickman case, they didn't do in the lockdown context in Pennsylvania. I don't believe they did it anywhere. We've seen no evidence of published evidence that they did so. But in this context, they're statutorily obligated to do it, because the concern was they didn't want this to be a power grab by the CDC or the FDA. It was not a loophole meant to swallow up all the other rules and principles governing public health. And it was a careful balance between informed consent and protection of the public from a dangerous disease. And that's why it required this level of analysis. And it included also requiring them rule out that any other alternative therapeutic treatment or other public health intervention could work, including self-quarantining and so on and so forth. And so that's the concern, is that they're rushing this vaccine in ways that do not meet traditional FDA standards. And in order to do so, they have to go through other unique standards. And there isn't evidence that they have. And he's challenging whether that evidence even exists. And is saying the available public evidence says otherwise. I mean, he points out that for those between the ages of 12 and 15, this is what's alleged in the petition for an injunction. And that's why it's kind of a lawsuit, but kind of not yet. They're going to be bringing a suit later on. But this is a way of bringing a suit. It's just old. Larry likes a lot of these old principles, petitions for injunctive relief, so on and so forth, as opposed to a complaint for legal remedy. The old equity legal distinction, for those that may not know it, exists in Tennessee, chancery courts versus circuit courts, civil courts, etc. But is that he just goes through and says, look, the risk from the publicly available data is almost statistically 0%. It's like 0.00000 like 365.
If anybody sees me looking off to the side, it's because I'm getting the screenshot of the section. I'll just read it. It's an allegation, people. It's not a proven fact yet, but it will be proven or not proven. It says the balancing test required by section 360 BBB 3C2B cannot be satisfied, since the risk from COVID to 12 to 15-year-old children is statistically zero. And that's not zero, rather statistically zero, meaning rounded down, it's effectively zero. There is no real or material benefit to this age category of using these experimental vaccines. At the same time, the risks of using any untested drug are always substantial, and in this case, the injections are already proving to be dangerous, even on the basis of the false and or misleading statistics promulgated by the DHHS, Department of Health and Human Services, because what they're basically saying, it's also fleshed out in the allegations, not proven evidence yet, but they're basically saying they're tinkering with statistical results in order to fabricate, exaggerate, create, or if you believe it, they're using statistics to inflate the effectiveness of the vaccines by how they're testing, who they're testing, and the criteria for positivity among the vaccinated, which for some reason changes from among the non-vaccinated. And so they're basically saying, even by the own inflated or conflated statistics that they're producing, statistical zero risk for an age group that they want to then use its emergency use to compel, it doesn't even fly by their own precedent or their own criteria.
And why it's very important is this goes back to my debate with Dershowitz, which people can go and find on Viva's channel, which is that he recognized that there needed to be a substantial risk of severe bodily harm to be doing these activities, particularly when it gets to the coercion state. And the fear is that if they can do emergency use drugs that then are later mandated by employers or educational institutions for something that poses a risk of death of 0.0000 whatever 3, 4, 5%, that's way under 1%, then they could do it for anything, because there's all kinds of diseases that can come around that have that small tiny level of risk. There's all kinds of activities in society that pose that level of risk. I mean, could you start to ban? You can't drive bicycles. You can't drive your own vehicle.
Well, no,
you have to do this. I mean, it could keep going if this tiny level of risk allows for massive federal intervention in people's everyday lives.
I say the only distinction is you have to compare to contagious viruses, contagion versus accidents and general risk. I think that's the only.
From a regulatory perspective, yes. But I think the broader constitutional concern is, if you could do it in this context, why couldn't you say anytime that a 0.00345% risk exists in any aspect of life, we have an obligation as a matter of national security to start to run and control your life and dictate what you can do? Because if you could do it in this context, at least constitutionally, then you could do it in any other context.
And now, for anybody who doesn't follow us on Locals, and this is not a cheap plug, it's just Robert put out something the other day, which I had never actually, it was a defense of this position as relates to vaccination. And Robert brought up something which I never really thought of or fully appreciated or fully fleshed out in my own mind, which is that the risk here has to be from asymptomatic or pre-symptomatic spread, because from a legal perspective, if someone is diagnosed as having COVID, and we can all recognize that that's a serious thing, there's quarantine measures that can apply to that person, such that the vaccination is not useful or relevant to that point, but that there's an alternative method of dealing with it that does not involve these potentially constitutional violations. So the real risk has to be asymptomatic and pre-symptomatic evidence of transmissibility to justify this policy. And then you're at a threshold that's even exponentially less than the stats as we know them, which come from actual infection. So everyone, let that sink in, because in order to justify any form of compelled vaccination, at least in a court of law, and Robert puts out the defense, which is playing the intellectual game, the thought experiment, it has to be that pre-symptomatic and asymptomatic spread is so substantial or sufficiently substantial that it could compel any sort of policy as relates to vaccination. So in
this context, if you applied that math, you're probably talking about vaccinating this group. I believe there's put it this way, the feds have not created any cost risk benefit analysis that they've published to anybody that I know of. So, and in my view, is the evidentiary burden is on them. But but with the available information, it is likely that this vaccine would not save any lives for that age group of 12 to 15, because the statistical odds are so small that they will, in a pre-symptomatic or asymptomatic state, spread it to someone else that causes their death, because it's substantial risk of severe bodily harm. And they're already a low risk group to begin with, from getting, at least that this age group would die. So you'd have to argue we're vaccinating them to prevent transmission to someone else. And even in that context, it's going to be tiny. But the idea that anybody within this age group would die because it was spread to them because of an absence of a vaccine is literally, more than 1 in a million is what the odds appear to be as I've seen them. So if they have other data, they should produce that data.
42 is binary. 42 is binary is the code for asterisk. So Viva, this is your asterisk birthday, kind of appropriate. Yes, it is. Thank you. No, but Robert, okay, I want to make sure I understood this part. The argument is going to be that you need to vaccinate this group, not because of the risk of COVID harm to them, but because of the risk of COVID harm to grandma. So if they get it and transmit it along.
Potentially. I mean, right now, apparently it was initially presented as being beneficial for this group, not being beneficial for others. And so that's why the injunction request focuses on that, saying, well, as it relates to this group, the odds that this group suffers death from COVID is tiny. And particularly when it relates to alternative public health interventions, such as quarantines for those who are symptomatic. And so when you add that component, he didn't even add that component, but the evidentiary record may go there. Then you multiply that the tiny risk that already exists, and you get a much tinier risk. And at least from that standpoint, and that's because for kids there's separate legal additional thresholds. That it's supposed to be beneficial for the kids. We're not that you're doing it to prevent the kids from transmitting it to others, but that you're doing it to prevent kids from getting it. And that's where some of the problem applies. So I think it's a good argument. Now, whether the courts are going to care is another open question, but they needed to start the process of forcing them to comply and at least produce the evidence that they did comply. What is their cost risk benefit analysis? And does it meet the evidentiary threshold? Can it be whatever they want it to be? Are there some sort of limitations on this? Dershowitz seemed to recognize, the risk needs to be really substantial. I think I even asked him if it was like 0.1%, is that worth it? He said no. Now that's because, I don't know if he thought through that the evidence is more on my side than on his side. I think, assumes the risk is higher than it is, at least from the data I've seen. And my main thesis for that is if the evidence was the other way around, the government would be putting it out there. They would be saying, here's the risk and here's why it's so high. They have stayed away from this all the way through everything they've done in the public health intervention space.
Yeah, and this is something we talked about with the VAERS reporting system. The VAERS reporting system is people report, and then
by the way, if they lie, it's a federal crime. Unlike the fake COVID passports that they claimed was magically a federal crime, which was far from clear to me. If you lie in the into the VAERS database, that is a federal crime. So, that's one of the highest, unlike, for example, to certain degrees, they're discovering there's new studies that suggest they may have misrepresented or got wrong the number of hospitalizations of certain groups of people being tied to this. But if you lie about this, and generally when they've done studies, they find that the reports to the database understate the scope of the risk, that usually only 10% or less of people who experience an adverse event after this time period, again, that just says correlation, doesn't prove causation, but 90% of them never report it because they don't even connect it, they don't even relate to it, so on and so forth. So but people following that database, like Alex Berenson, again, sort of a liberal, old school establishment kind of journalist used to be for the New York Times before he wrote spy books, is that, as he's pointing out, this is off the chart. Same thing, Bobby Kennedy was banned off of Instagram for just talking about this database. So it's extraordinary why is everybody so scared of the information in this database if everything's so safe and effective and good for us?
Well, we're gonna get there in a second, actually. But from the legal perspective of this lawsuit, it's an 80-page injunction. I don't know how much more they can flesh out the factual basis, but from a technical, you might hear someone screaming upstairs. From a technical perspective, how does it work? Now, this was drafted as an injunction. What time frame do they have to convert this into or draft or file an additional lawsuit, which will serve as the underlying lawsuit itself?
Oh, they don't have to do that if they don't want to. And it's sort of a procedural mechanism. This is a temporary emergency preliminary injunction request. The court can rule on that without that. Now, they have to serve this, obviously, on the defendants. Defendants appear, defendants brief it, maybe evidentiary hearing, and then make a decision. The key is going to be whether they get a judge that's open-minded on this topic. Also, this is an area that has very, very little litigation record in it. And so there's not a long established record of it. And there's a bunch of other lawyers working with Larry Beecraft on this. Joey Gilbert out of Vegas, a whole bunch of people across the country representing this frontline doctors group that has expressed a lot of concern about, rushing the science. Brett Weinstein has expressed the same concerns. I mean, so it's not, and they're not saying that this is that the COVID vaccine is bad or anything else. They're saying there's a proper process to go through here, and we're not doing it. And that's where the risk comes in. And so that's what the lawsuit raises is, hey, we're not following our own procedures to make sure we've done the right risk analysis here.
Okay. The lawsuit itself, I'm going to try. I have trouble converting PDFs into HTML so we can share them more easily. So if anybody has a hack for that, email me at david@vivafry.com so that I can convert a PDF into a link that I can share with everybody. The lawsuit is interesting. It's hyperbolic. It's inflammatory. It's shocking. It's in your face. It is, as Robert would say, walking into a courtroom and throwing bombs. I presume, they're going to be able to make evidence of the meaningful aspect of this. But at the bottom, at the end of the day, a lot of the allegations are that there's no evidence to justify what is being required, which is the inversion of, effectively that's the way it needs to go. Prove that what you're doing is justified on all these levels. And until such time as you do, don't compel people, let alone children, to do certain things. Agree with it or disagree with it. That's the nature of the lawsuit. Time frame for this? Because what is the time frame for the implementation of the policies that are at the core of the lawsuit itself?
I mean, they already did. They just they filed the suit almost immediately, as soon as they said that they were going to do emergency use authorization for that age group, and so based on that is why they filed the suit when they did, and that's why they're seeking emergency relief. They don't want it to be authorized for that age group. And so we'll see whether now the court could say okay to that and then have a hearing on other aspects of things. So, there is some leeway with the court. But I hope the court takes seriously that that what they're raising is that they're not following the process by which we can have confidence in the outcome, and that there's contrary evidence to suggest that process would refute the outcome they've come to. And on both grounds, I think it's a well-grounded case. It's will the court listen or care in this space when it's something they're unaccustomed to dealing with, and they often defer to the public health authorities in the pandemic environment.
And now, actually, I want to get into another technicality about Robert F. Kennedy's. Now, he's filed. It's not a lawsuit. It's a petition, and I don't understand the procedural mechanism that he's going through, what its limitations are, and what its benefits are.
So, what is Kennedy understands very, very well the entire process of this thing intimately. He was the one who first told me that there's emergency use authorization limitations that should be applicable here. And that was the first time I had heard of that. And it's because he understands all the internal process. So it's a way to try to go directly to the source. And you have a right to bring a citizen's petition on certain grounds to challenge an emergency use authorization vaccine for, in this case, children. And because his group represents children, that's his focal point. So, he's not going to be bringing suit for adults because that isn't part of his group that he represents, the Children's Health Defense. So that's why he brought the action. So it's a way to go directly to the regulatory agency and force them to address it. There's different ways they can avoid it, different ways they can respond to it, but their failure to respond can be used as additional grounds to bring suit or support existing suits.
Now, is there a threshold of signatures that it requires? Is there a threshold of anything, or can any interested party file the petition?
Well, he's definitely brought it in the procedurally correct way. I don't know all the details of that. I just know he knows that process better than anybody.